Hello everyone, welcome back to the channel. Today we are in the video 3 of the NGT Act series and we are going to concentrate on the chapter 3 which lasts from section 14 to 25. The most important content for the UGC net is provided and explained by me in the part 1 and 2. So if you have missed those videos, please go watch those videos and come back to this video. Now coming to the section 14. This section deals with the jurisdiction of the entity. Okay, it says that the tribunal shall have jurisdiction over the civil cases where substantial question related to environment is involved. So what is substantial question related to environment? It is defined under section 2M, which we have already seen. Okay, also such question arises out of the implementation of the enactments specified in schedule 1, that is those 7 acts. Okay, also it has stated that the tribunal shall hear those disputes and settle such disputes and pass order for that. Also, the tribunal should not entertain any application which is filed after 6 months from the date of cause of action. So, application before this NGT should be filed within 6 months from the date on which the cause of action arose. But if after that it should not entertain, is what subsection 3 says. But also there is a provided clause that in case that applicant has some sufficient cause for not filing the application within the said period, he can be given an additional period of 60 days. That is what section 14 is about. Now moving to the section 15, it is about the relief, compensation and restitution. So the tribunal has the power to order and provide relief and compensation. Okay, the first one is relief and compensation and the second one is for restitution of the property damaged, and C is for restitution of the environment for such area or areas. So three types of order this tribunal may make, that is relief and compensation to the victims of pollution and environmental damage, and restitution of property, and the other is restitution of the environment. In the second subsection it is said that the claimant can get compensation from both, that is the relief from both Public Liability Insurance Act and under this section also. Okay, so the relief and compensation and restitution of property and environment referred in these clauses shall be in addition to the relief paid or payable under the Public Liability Insurance Act. Okay, so they can claim under both these. And the third subsection says that this application should be made within a period of 5 years from the date on which the cause for compensation or relief first arose. So in the section 14 we have seen that is 6 months, that is about the environmental dispute, but this section is about the consequences like relief, compensation and restitution. This 5 years period is given because the scientific evidence and the consequences may be appeared later, may appear later. So this 5 years period was given for this compensation. Okay, then in case there is sufficient cause for not filing within this 5 years, again as already said, 60 days may be given in addition. Then the fourth clause says that the tribunal, while giving this relief, they may give it under separate heads specified in schedule 2 so as to provide compensation or relief to the claimants and for the restitution of the damaged property or environment. Like under separate heads specified in schedule 2 means it may give compensation like 4 lakhs for death, 4 lakhs for the partial disability, 4 lakhs for the damaged property. Like this they may give it under separate heads. Okay, that is what subsection 4. Subsection 5 says that every claimant, in case he gets some compensation or relief under any other court or authority, it should be informed to this court, this tribunal also. Okay, since the amount may vary depending on the relief already they have claimed, the court may decrease or increase, no, for that it should be informed. That is what subsection 5 says. So section 16 is about the appellate jurisdiction of the tribunal. On what orders or decision this tribunal is having appellate jurisdiction is provided under these clauses. And the A clause is about in case an order is passed by the appellate authority under section 28 of the Water Prevention and Control Pollution Act 1974, the appeal will lies with the NGT. And the second one is the order of state government under section 29 of the Water Control Prevention and Control of Pollution Act. Then the order of the board under section 33A of the Water Prevention Control Pollution Act 1974. So under the Water Pollution Prevention and Control of Pollution Act, there are three bodies which is giving order or direction. The first one is the appellate authority under 28, state government under 29, and a board under 33A. For all these three, the NGT is the appellate authority. Then coming to the Water Chess Act, there is appellate authority under section 13. For that also appeal lies here. Then for the Forest Conservation Act under section 2, state government may make some order or decision. For that also NGT is the appellate authority. Then Air Pollution and Control Act, Air Prevention and Control of Pollution Act, appellate authority under section 31. Then Environmental Protection Act section 5. Okay, under section 5 the direction may be challenged here. Okay, so HUD says that in case environmental clearance is granted by an order, then it can be challenged. Also, I says in case the grant of clearance is refused, then that order can also be challenged by the challenge before the NGT. Then J says that any determination of benefit sharing by the National Biodiversity Authority or State Biodiversity Board. So those or determination can also be challenged. And this section specifically says that the appeal should be filed within 30 days from the date of the aggrieved order. Okay, order or decision or determination. Also it says that in case there is sufficient cause for the delay, it can be extended, the period for filing of appeal can be extended for a further 60 days. Okay, then coming to section 17, it speaks about the liability to pay relief or compensation. So it's basically based on the polluter pays principle. So it says that where death or injury to any person or damage to a property or environment has resulted, then the person responsible shall be liable to pay such relief and compensation specified under the head specified in Schedule 2, as may be determined by the tribunal. So it stresses the point of polluters pay principle. Okay, that is what it says. Then in 2 it says that in case that is not by the act of a single person but a result of combined or resultant effect of several such activities, operations and processes, then what the tribunal do is it apportion the liability for relief or compensation among those responsible for such activities. Like they will apportion, this person is liable for this much amount, this person will be liable for this much amount, like that they will apportion the liability for relief or compensation. And the third subsection says that it is if it is in case of accident, the tribunal may apply the principle of no fault liability. So they will not take into consideration the polluter pay principle, but they will take the principle of no fault liability. Okay, then coming to the section 18, it is very easy. It says who should file the appeal or application. So just have the general understanding. The person who sustained the injury can file. The owner of the property to which the damage has caused can file. Then where death has resulted from the environmental damage, their legal representatives can file, and any agent duly authorized for such person or the property and their legal representatives can also file. Any person aggrieved including any representative body or organization, even they can file application. Then the central government or state government or union territory administration or the central pollution control board, state pollution control board or pollution control committee or local authority or any environmental authority constituted under the Environmental Protection Act or any other law for the time being force. These bodies can also file. So these bodies also have the locus standi in case of an environmental issue. This is what you have to keep in mind. Also, it says that in case the application is filed within 6 months, that application should be concluded, disposed of. Okay, like expeditious decision should be given, is what given in this subsection 3. In section 19, it is about the procedure and powers of the tribunal. It says that the tribunal is not bound by the procedures provided under the CPC. Okay, so no need to follow those procedures, but it is guided by the principles of natural justice. This you should be clear. Okay. Then second one is that it says that the tribunal can also regulate its own procedures. Then the third one is it is not bound by the rules of evidence. So it is not bound by the rules of CPC, it is not bound by the rules of Indian Evidence Act, and it should be guided by the principles of natural justice, and it can regulate its own procedure. Then the fourth subsection says that it will be considered as a civil court. The tribunal will be considered as a civil court, and it will be vested with the same powers as that of the civil court under the CPC, like summoning, enforcing the attendance of any person, requiring the discovery and production of documents, receiving evidence. These all powers is vested with tribunal also. And then the fifth subsection is all proceedings before the tribunal shall be deemed to be judicial proceedings within the meaning of section 193, 219, 228 for the purpose of section 196 of IPC, and the tribunal shall be deemed to be civil code for the purpose of section 195 and chapter 26 of the Code of Criminal Procedure. This was once asked as MCQ. Many people were confused because since they have given IPC and CRPC, these people were confused civil code with the criminal code, and they chose the option criminal code. So you have to be very clear that it is deemed as judicial proceedings as well as the civil court alone. It never serves the purpose of the criminal court. Okay, because it is related to the compensation alone. In the preamble itself it is very clear. Then moving to the section 20, it says while deciding the cases, the tribunal should apply the principles of sustainable development, precautionary principle, and polluter pays principle. So this section 20 is also very important. Then 21 is about in case the decision is like in the decision there is a majority opinion, that will be binding. But in case the opinion is equally divided, like one member has given allowed the application and the other member has refused, dismissed the application, then what will prevail? In such cases, what the tribunal will do is the chairperson will hear such application. Okay, so apart from that two members, it will go to the chairperson and he will decide, and then the tie will be broken. Okay, but in case if in that two member itself chairperson is a member, then how comes it will come to the deadlock will be removed is then, so the example is there is a chairperson and another member. So the chairperson allowed and the other member dismissed. So what happens is then this case will be again referred to other members of the tribunal who shall hear such application or appeal and decide. So as a third, it will be referred to a third member, and the deadlock will be removed in this way. Okay, then so section 22 is about the appeal to the Supreme Court. In case a person is aggrieved by the order of the NGT, they can go for appeal before the Supreme Court within 90 days on the grounds specified in section 100 of the CPC, that is a substantial question of law. So in case they are not going before the Supreme Court within 90 days and they are having sufficient cause, the appeal can be allowed by the Supreme Court even after the 90 days. That is what section 22 says. Then about cost, the entity can also impose cost on the person, and in case the claim is not maintainable and it is found false or vexatious and such claim is disallowed, the tribunal can even award cost for that, including lost benefits due to any interim injunction. This can also be included. Then going to the section 24, this amount, if amount is like ordered as a compensation in case of damage to the environment, this amount will be remitted to the authority specified under section 7A of the Public Insurance Liability Act, and these authority will remit it credited to the environmental relief fund, and this amount can be used by the utilized by the persons or authority in such manner for the purposes of the environment. This is what section 24 says. Then moving on to the section 25. Section 25 is about the execution of the award or order of the tribunal. So the order of the tribunal is considered to be the degree of civil court. So for this EP petition can be filed, and the tribunal it is also given the tribunal shall have all the powers of the civil court. So also the tribunal may transmit any order or award made by it to the civil court having local jurisdiction for execution. Okay, this can also be done by the tribunal. So in case a person responsible for death, injury to any person, damage to a property, environment, and he fails to make the payment or deposit of the amount, it can be recoverable from the aforesaid person as arrears of land revenue or public demand. This is what provided under this section. So very easy from just remember the short titles of the section 14 to 25 so that you can easily give answer to the MCQs. The major question they will ask is they will ask you to arrange the short titles in a chronological order. So study that, like section 14 is about the dispute jurisdiction, 15 is about the compensation, the 16 is about this, 17 is about this. So be clear on that. Okay, thank you for watching the video. For the rest two chapters, view the part 4 and 5 of the NGT video series. Thank you.